Good morning, everyone. This is Board President Sonia Early of the California Physician Assistant Board, and I'm calling the meeting to order, and it is now 8:33. Today's date is March 4th, 2024. Ms. Herr, can you call for the roll?
Charles Alexander,
Present.
Juana Renta,
Present.
Sonia Early,
Present.
Ben Hawkins,
Here, remote.
Dave Mendoza,
Present.
Vasco Diakis,
Present.
here. Who's the roll call?
Excellent. I believe we have a quorum present. I will move on to the first action item on the agenda, and that is approval of the November 6th, 2023 board meeting minutes. I trust that everyone has had an opportunity to review those. Do we have any comments or additions or corrections?
Madam President, I would just like to add again that I want to thank Jed Grant for his contributions. And it was great to see former President Sachs here as well in connection with that.
Yes. Excellent. Anyone else? Okay. I'd like to call for any public comment. I'd like to ask for a motion. Does anyone have a motion? Can they approve the motion for the minutes to be approved?
Oh, I apologize. This is the moderator getting a chance to ask for people on the WebEx call if they would like to do public comment. Real quick.
Moderator, we'll be doing that after the motion.
Oh, okay. My apologies.
No, thank you.
Thank you. All right, so we have a motion. Do we have a second?
Yeah, this Deanna, I will second the motion.
Awesome. All right, so moved. And now I'd like to take public comment. Thank you, Madam Moderator.
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. All right. Ms. Herr, will you call for the, another public comment in the room? All right. Now we can, Ms. Herr, would you call for the vote?
Charles Alexander,
Aye.
Juana Renta.
Aye.
Sonia Early,
Aye.
Dave Mendoza.
Aye.
Vasco Diakis,
Aye.
Deborah Staff. Aye.
Awesome. The motion stands approved as read. All right, and I will move to agenda item number 4. That is public comment on items not on the agenda. And just to note, the board may not discuss or take any action on any matter raised during this public comment section that is not included on the agenda, except to decide whether to place the matter on the agenda for future meetings. Do we have any public or any comment in the room? Or any public comments?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and it appears there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. All right, thank you, Madam Moderator. Moving on to agenda item number 5, President's Report. Vice President Deon Kidd and I, as well as our Executive Officer, Ms. Khan, meet on a regular basis, and we meet bi-weekly to address any information that's pertinent to the PA board. She also updates us on any staff changes or any changes that are happening in the government, and she's doing an excellent job with keeping us informed. I would like to welcome back one of our former attorneys, Christy Shields. And so she was here some time ago with all of us. And so I'm comforted that she is back with us to lead us and help us on our legal journey here. Also, I'd like to welcome Ms. Herr Pearl Her with us, and she's our enforcement and licensing technician. And this is her first board meeting, and she's already had things for us to sign, and she's taking care of us quite well. So she's been trained quite sufficiently. At our last meeting, as board member Arminta mentioned, that we did sign off on 2 of our beloved board members, Jed Grant and also Jennifer Callquist. And so that left us with significant vacancies. So our board member team is comprised of 10 people. And so we have 3 vacancies. So usually good people know other good people. So if you know of any great PAs that would like to volunteer their service to us, please direct them to us or to our website so they can fill out the application and hopefully be a part of our dynamic team. With that, Jennifer Callquist signed off of the legislative committee, as well as myself. And so I just wanted to make sure that Ms. Dillon is sufficient in the team, and so we can provide her support if she so desires that. But I think she's doing a wonderful job. She doesn't need our support. She actually informs us. So if you do need additional support, just let us know. Okay. And I personally, for the first meeting of the year, would like to thank all of our fabulous board members. We have an outstanding team. We also have an outstanding PA staff team and an EO, and our legislative team is just to die for. So I feel that I'm comforted and we're in great hands. And so I do feel like we have a dynamic team. So I just want to thank you up front for the year to say thank you, and I appreciate your service and what you're doing for us. So any comments from the floor? All right, any public comment? All right, and so we will continue to move on to the.
I apologize. This is the moderator. At the direction of the board, I've opened up the Q&A feature for public comment for members on the WebEx call. You'll be given, this is, if you would like to make a comment, you can click the Q&A icon or use the raise hand function. All right, it appears there are no requests for public comment. Would you like me to close that Q&A feature?
Yes, please. All right, we're moving on to the next agenda item, number 6. We have the executive officer's report. Ms. Khan.
Good morning, everyone. I will start off with personnel update. Effective January 30th, 2024, Armando Melendez has been promoted to Special Investigator SI position. As mentioned in the November meeting, the non-sworn Special Investigator position was established at a limited term for 24 months to collect workload data and cost savings. The board has identified several case types that can be investigated and referred for prosecution without the use of Division of Investigation, DOI, Health Quality Investigation Unit, sworn investigator. Redirecting such cases to non-sworn personnel will streamline processes and reduce costs. Many tasks associated with investigations can be performed by non-sworn investigators, such as detecting and verifying violations, interviewing witnesses, gathering information, analyzing testimony, serving legal papers, or serving as an expert witness, amongst other non-sworn duties. The board will continue to utilize HQIU for criminal investigations that can only be handled by a sworn peace officer. Mr. Melendez brings over 22 years of comprehensive experience with a strong understanding of the Physician Assistant Board, PAB, and the Medical Board of California, MBC functions. With a background as a complaint analyst for the PAB over the past 3 years and 19 years of service at the MBC, Mr. Melendez has excelled in various roles, including the Central Complaint Unit, Licensing Unit, and Business Services Office and Outreach Program. His expertise spans the review, analysis, interpretation of laws, policies, and regulations, including the Physician Assistant Practice Act, Medical Practice Act, California Code of Regulations, and the Health and Safety Code. Over the past 8 years, Mr. Melendez has managed a diverse caseload, handling cases related to quality of care, office practice, subsequent arrests, impairment, and unlicensed practice. In addition to initiating and reviewing cases, he is proficient in conducting interviews, corresponding with licensees and facilities, and managing the medical consultant program at both MBC and PAB. Additionally, Mr. Melendez has worked part-time as an athletic inspector with the California Athletic Commission and has received an extensive training in evidence collecting, substance abuse identification, and enforcing relevant regulations. Please join me in congratulating Mr. Melendez on his promotion. Next is on February 13, 2024, Administrative Analyst Ariel Gompers accepted a promotional position with the Office of Administrative Hearings. I want to correct myself, it's Ariel Zegas, not Gompers, sorry. I extend my heartfelt gratitude to Ms. Zegas for her dedication, hard work, and contributions to PAB, and wish her great success in her new role. Karen Halbo, Regulatory Counsel, has accepted a great opportunity with the California Department of Industrial Relations and is no longer with the Department of Consumer Affairs. While we miss Ms. Halbo, we are excited for her new opportunity and wish her all the best in her endeavors. I am pleased to announce that Christy Shields is stepping in as our Regulatory Counsel. Ms. Shields, who has previously served as the board's legal counsel, bringing a wealth of knowledge and expertise to this role. She was instrumental in working with members, staff, and the legislature on Senate Bill SB 697. Ms. Shields has been with DCA for over 20 years and is an attorney at core. We look forward to Ms. Shields' continued contributions to the success of the board. Lastly, outreach. Due to the current state budget deficits in fiscal years 23-24 and 24-25, the board will temporarily suspend all outreach activities until further notice. This includes non-essential travel plans, both in-state and out-of-state, such as participation in seminars, conferences, and training. Only travel necessary to conduct official state business will be permitted during this period. That concludes my report. Any questions?
Excellent. Thank you, Ms. Khan. Public comment.
Dr. Hawkins.
Oh, Dr. Hawkins. Thank you so much. Good morning, Dr. Hawkins.
Good morning to everyone again. It's nice to be with you, albeit remote. Roseanne, I just want to know, do you have any specific comments about the impact of the limitations imposed by financial restrictions on the PA board being able to do its job in general?
During our strategic planning, one of the things that we, highlighted was doing more outreach. This has hindered that. It has set us back a little bit because we had plans to go to CAPA conference, and we had a Federation of State Medical Board, conference that we needed to attend. And there's, CAPA, has, given us opportunities to attend some of their conferences, which we are not able to. So yeah, it has kind of set us back in that realm.
Yeah.
So. Yeah.
We see the same on the medical board. Thank you for that information. That ends my question. Thank you.
Thank you. Any other questions? Public comment?
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and it looks like we do have a request for comment from Teresa Chien. And Teresa, you will be given 5 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
I'm speaking, I'm speaking on behalf of the California Academy of Physician Associates. While we're disappointed to hear that these financial restrictions have limited the ability of the PA board staff to attend our conferences and meetings, please know that whenever the PA board is ready, CAPA will always have a complimentary exhibit table at all of our conferences available to the PA board.
Excellent. Thank you, Ms. Chan. We appreciate that. Any other public comment?
This is the moderator. Appears there are no further public comment on WebEx. Would you like me to close that Q&A feature?
Yes, please. Okay, moving on to agenda item number 7. We have board activity reports. We will start with licensing, Ms. Caldwell.
Morning.
Good morning.
So I'm Julie. I'm the licensing analyst, and we'll start with licensing population by type. Is the first report for my unit, and this gives you an overall breakdown of where we're at with the different types of licenses that we have going on, from current to retired to canceled. So currently we have 17,441 individuals who are licensed and current. We have 30 that are current inactive and 2 that are current temporary family support. So a total of 17,473 individuals that are licensed to practice right now. This gives you an overall plan, how many individuals, how many applications we received, how many individual licenses were issued, and how many licenses were renewed. And this falls between October 1st, 2023 through December 31st, 2023. So for initial physician assistant applications, we received 447 applications. We approved 453 applications, and we renewed 1,933 licenses. We also received 1 application for the temporary military physician assistant.
Excellent. Are there any questions?
Pending application workload, it gives you at a glance how many applications are coming in to the board that have been assigned to an analyst. And then it gives you a breakdown as far as where we're at in that process. And we are meeting the board's current 30-day timeline. So once the application is received, it doesn't get assigned necessarily right away. Depends upon the day of the week that it is submitted. Sometimes they're submitted without payment, so we don't actually assign them until the payment is submitted as well. So we do have some new updates for initial application, and licensees are advised at the time of the paying, getting towards the end, we have what's called an attestation. And they've been advised once they bubble in that attestation, their application is considered submitted. They can't make any changes, can't be reopened. We can actually add like an addendum, an email or something like that if they forgot to disclose something. We accept an additional email and addendum to the application, but we don't remove the application to allow them to start over if they've just forgotten to disclose maybe an EMT certificate or something like that. They're also notified at that screen that if they don't make a payment for that application within 30 days, that application will be withdrawn and they will have to reapply. So over the last couple of years of doing this, we average about 50 to 60 individuals that stay in the system without payment. And then after a year, their applications automatically drop off. So we're just trying to eliminate that additional group of applications that are in the system without payment. So we don't count them on any of the statistical information. But we are just updated that. So that this pie chart gives you a breakdown of how long the applications are in the system. And typically they range from anywhere from 30 days, they'll get reviewed and they could be issued a license if everything is in-house. If not, then that's when they start turning in one of these colors of the pie. And that's at the applicant's, that's their responsibility to get themselves licensed at this point because they've been reviewed. We are just waiting on documentation from them.
I have a quick question. So it seems there's 119 that are 91 plus days. And so I'm assuming those are incomplete applications.
Correct.
In terms of, is it just payment or documentation? What type of documentation?
Any individuals that are included in the pie, this information for the pending application workload, they've been reviewed. And then these timelines are the applicant's responsibility to complete their application. So for example, they could apply January 1st, but not be graduating from school until April or May.
Gotcha.
So they're going to fall way into this pie of the red. And that doesn't necessarily mean that they've done anything wrong. It's just that that's the timeline that they've fallen into by applying so early. We do have information on the application instructions, both online and on the board's website, that advises applicants who are in school right now not to really apply any earlier than 30 to 45 days prior to graduating from the program or taking the chance. And that is to help eliminate the possibility that their application may expire if they actually have a failed examination. So they have to wait a certain amount of months with the NCPA. So we're just hopeful that, you know, everybody just kind of applies within that 30 to 45 day window of either graduating or taking the exam.
Does this increase your administrative burden for people who apply earlier?
No,
Okay.
not at all.
You're still able to get everything in within that
No,
30
yeah,
days?
everybody gets reviewed, everybody gets an update, doesn't really matter, but it is, we do have some applicants who are in the door for an entire year and they never submit any supporting documentation for the application, then we just fund for the initial license and get that year. We consider them abandoned. So, and again, that's not really any additional work. It's a simple form that we fill out for a refund request. But yeah, we're just trying to help them utilize their year that they're given correctly. So, and to avoid having to reapply.
Thank you.
I have a question, if I may.
Yes.
So my concern is with the big budget crunch and we're going to see, oh, we're not efficient. What are you doing? We're going to see those questions somewhere down the line. So I understand what you're saying in terms of this pie chart, but is there a way that's convenient to footnote this report, which is public, that says X percentage are early applicants? So that kind of excludes that from us having any responsibility. And X percentage are back to the applicant because they need to provide more information. Is there any way to incorporate that in this report that's sufficient? I don't want to increase your burden.
I don't think there's a way to separate all the reasons for deficiencies. They're deficient for a specific reason. And even if we were to toggle that into the BREE system, it breaks it down to all supporting documents have been received. We do have specific line items for maybe the PANT examination, maybe the program certification, and then everything else is general. We do have another specific item for the check, but we have license verification. So we could do it maybe to see if we could figure out if that information can be broken down as percentage. But the majority of the delay in issuing a license really stems from the score and just waiting for them to graduate from school and taking the exam. And then the second would probably be verification of licensure from another state. We do accept verifications online. We do work with applicants. If that state is no longer providing a written or electronic verification, we will go to their website and use the primary source and pull that information ourselves. It's rare that that happens, but typically those are the two reasons that for the longest delays. Sometimes background check, but not.
Well, let me get your thinking on this. Would it suffice then just to note at the bottom of this report in the summary fashion, just what you said, some of this aging includes early applicants
Absolutely.
without a percentage. Some of this on these pie chart are for whatever the reasons are that they're delayed. I think if we put that in the report, if somebody wants to criticize our efficiency, then we say, hey, you know, we can break down the data if you really want to get into it, but here's the reasons why.
Absolutely. Yep.
Okay.
Great. And we have a question from Dr. Hawkins.
Yeah, thank you very much. And this question may be better asked in another section, but I'll ask it now. It's a workforce questions. We're aware that physician shortages do exist in California. Health provider, actually more correctly, I meant to say workforce, medical provider shortages exist in California, and they will not be reversed or satisfied by physicians, nurse practitioners, and PAs. My question is, do we have an idea where the PAs are coming from, that 17,000? Are folks who are coming out of school now in California, trained in California, staying in California, or getting folks coming from other places? Again, this may be answered in a different section. I'm just asking for a comment about how PAs are contributing to the workforce deficiencies in California. That's the purpose of my question. Thank you.
Thank you.
I think in past meetings, the impression that I got from
You're breaking up. It's a little hard. I heard past meetings, but I couldn't understand the rest. I'm sorry.
I think previous meetings, we have discussed for the Workforce Education Committee that there's a trend that a lot of the physician assistants that attend school in California tend to stay in California. We don't solicit that information from our applicants when they're applying. There's no question on the application, were you educated here and planning to stay here? So that might be a better question, whoever is.
Yeah, so there is, so the majority of PA students that train in California stay in California, the majority. There are some outflows to other states, but the vast majority do stay. So we do have a significant PA footprint from those PA programs in terms of their students repatriating, back into the California workforce.
Excellent. Excellent. I just want to, I'm sorry, Dion, go ahead.
Yeah, so yeah, for sure. We are seeing PAs, students and licensed PAs practicing within the state of California.
Thanks for that. And I just want to restate and clarify, workforce deficiencies will not be satisfied by physician assistants, physicians, and nurse practitioners at the current rate in the state of California. Thank you.
Thank you. Any other questions or comments?
I think that's it. Just that last report, the license performance measures, that just gives you an idea that we're meeting the board's 30-day window to provide a review of the application for licensure and provide an update to the applicant.
Excellent. Thank you, Ms. Caldwell.
Thank you.
All right. Next, we'll move to item B, which is complaints by Mr. Melendez.
Good morning.
Good morning.
I will be providing you a section of the enforcement activity report in regards to the complaints for the second quarter. We will be focusing on the second quarter, October 1st, 2023 to December 31st, 2023. As you can see, we have provided stats from the previous year. This report will also show how we're trending this fiscal year to the last fiscal year. Start off with complaints and volume. We have received 104 complaints. We have convictions and arrests that were received are 9. Total complaints received with 113. Intake. The intake average days are 6 days, so to initiate the case in 6 days. There are 0 complaints that are pending at intake. Complaints and investigations. Complaints, there were 6 cases that were referred to investigations. 117 complaints and investigations that were closed. There are 292 cases pending at the desk analyst. 47 cases that are investigations pending at the field. Investigation and aging. The average age of pending investigations are 291 days. Investigations that are 8 months or older, there are 30 cases. We'd like to move to the following chart. The following chart is on the complaint received by type, source, and if you have any questions, this concludes my portion of the report. If you have any questions.
Congratulations again.
Yes.
Thank you.
Very impressive resume. So
We're glad to have you continue in service with us. too.
absolutely.
I
Yeah.
appreciate the opportunity.
So any comments? Any questions?
Yeah, I do. And
Yes.
on, thank you. On investigation agings, it looks like we're slowly attacking that curve. Would you agree?
Yes.
Okay, I just want to make sure I was interpreting that right. Thank you.
Any other questions or comments? Excellent. Thank you, Mr. Melendez.
Congratulations. Thank you.
Congratulations again. Moving to item number C, discipline, Ms. Hayden. Good morning.
I'd like to present the discipline regulations second quarter, which is October 1st, 2022 to December 2023.
This is the moderator. I apologize. Whoever's speaking, could you be closer to the mic or talk louder? It's very hard to hear over the WebEx.
There's one there. One there.
Thank you. That sounds better. So for the suspensions, there were none this quarter. For the Office of the Attorney General transmittal, there were 8 cases transmitted this quarter. There are 48 cases pending, and the average age of the pending cases is 374. For the formal actions filed, withdrawn, and dismissed, there were 6 accusations filed this quarter. 1 accusation withdrawn and dismissed, and there was 1 statement of issues withdrawn or dismissed. For this next chart, there was, for the administrative outcomes and final orders, there was 1 license placed on probation. 2 licenses were surrendered, and citation and fines, there were none issued this quarter. Does anyone have any questions?
Yes, Dr. Hawkins. Regarding those cases that are in excess of 300 days, are there general reasons why those cases are there? Complexity, whatever you want to say. I mean, they may all be the reason for that long time frame may be too diverse to put them in a category. Just curious about the long cases.
So it's part of the legal process in discovery and setting up a hearing. Sometimes the hearing can take 3 months from the time all parties agree. So that's why the process looks like that at the time. So it seems like a lot. That answers the question.
If I may, Dr. Hawkins, so the short answer is due process. So when they set hearings, everybody has a chance to do their discovery, their investigation, and everything else. So this number, I mean, we a few years ago, I think it was in the 500 or 600,
Yeah.
wasn't it?
Yeah.
I think Mr. Knoch would agree also that this is not, from a legal perspective, this is not a shocking number at all.
I'm aware of that from my experience, and thank you for that.
Excellent. Any other comments or questions? Excellent. Thank you, Ms. Hayden. We will move to the next agenda item, D and E, with probation and diversion given by Ms. Gerard.
Good morning,
Good
Madam
morning.
President.
Good morning.
Good morning, Lord. Where is the microphone?
It's right here.
Okay, so this past quarter, in October, there were no changes. In November, 2 folks successfully completed probation. In December, we got a new probationer. The effective date was at the end of December, and we also had another person completed. And we had a voluntary surrender, and that person was from our told caseload. Are there any questions?
Are we still seeing a decrease since the pandemic and post-pandemic?
Ma'am, I think we're saying a slight decrease, but about the same.
About the
I don't
time?
want to have a spoiler for next quarter. It's averaging about the same over time, yeah.
Okay. All right, great. Thank you. Any other questions or comments?
I do. I just wanted to see, last time, I think each time I've asked you, how are you received in the field by probationers? And I just wanted to make sure that that seems to be professional for you and licensees are acting professionally towards you.
Yes, they are, sir. Sometimes they don't offer really quickly to shake my hand. But typically by the end of the interview, we're fairly more amicable. And sometimes I am shown the back door. They don't want to march me out past the patient.
Why are you wearing a badge or
No.
anything or?
No,
Okay.
sir.
Okay. Okay, well, I understand that, but I just want to make sure that licensees are being respectful and. Okay.
Sir.
Okay, thank you.
Excellent. All right. No further questions for probation? All right, we will move on to diversion.
Okay, yes, ma'am. Diversion again. I mean, you're seeing a slight increase because we had people. We were up to 5, but someone in October was no longer in the program because they no longer had a license. So we're holding now at 4.
Okay.
But potentially, well, that's a spoiler alert.
Excellent. Any questions? Okay. Thank you so much, Mr. Hart.
Congratulations.
Thank you so much. Excellent. Well, that concludes the board activity reports. Do we have any public comments for board activity report on WebEx?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment on WebEx, would you like me to close the Q&A panel?
Yes, please. Okay, moving on to agenda item number 8, Department of Consumer Affairs. Good morning.
Good morning. Judy Petrelli, it's good to be with you again. Thank you for the opportunity.
Oh, I apologize for a DCA speaker. It doesn't seem like we can hear you on the WebEx where you're at. You may either want to speak louder, almost like you're shouting, or if you can get closer to one of those mic pucks that's on the board member tables.
You know what, should we just move that table up closer to
We
us?
probably could, yes. We're going to take a brief moment to move the table up so that we can get better hearing
Madam
for the
President, I want you to
WebEx.
take note of how many people stood up to volunteer.
Yes, thank you so much.
What a great crew.
Great team,
Yeah.
teamwork.
Thank you.
So, you're welcome. So we
And you
just
may
moved the
wanna
table
go
up just a
to the
little closer so that we can get better volume.
Is this better?
Much better. Thank you.
Oh, all right.
Yes, it's better.
Thank you.
So, I'll start again. My name is Judy Petrelli from the Department of Consumer Affairs Board of Bureau Relations. Thank you for the opportunity to provide a DCA update today. On behalf of the department, I'd like to thank board members for your service for protecting California consumers. To begin my report this morning, I'll provide a business, consumer services, and housing agency update. Last month, the Business, Consumer Services, and Housing Agency officially welcomed Secretary Tamika Moss. DCA extends a warm welcome to Secretary Moss and looks forward to working with her. Next, Budget Letter 2327, current year expenditure reduction. Boards and bureaus are reminded of the Department of Finance's budget letter that directed all state agencies under the governor to take immediate action to reduce current year expenditures with certain exceptions for time-sensitive, emergency-related, mission-critical, or information security IT. BCA thanks the boards for doing their part to reduce expenses and find cost savings as part of a collective state agency effort. If you have any questions related to your current year expenditure reductions, please contact Board and Bureau Relations. Next, I have a diversity, equity, and inclusion update, also referred to as DEI. The steering committee will hold its next meeting on April 5th. The committee will discuss DEI actions, priorities, and language access. The committee will also elect a new chairperson. DEI training opportunities continue to be a priority for the department. As you may recall, DCA's solid trainers underwent a DEI certification program with the University of Massachusetts in April of last year. Before this certification, Solid offered 3 DEI-related courses for employees. After obtaining certification, Solid has developed 11 new courses. In 2023, DCA achieved 2,079 DEI course completion. I would like to remind the board of the training courses available to its members on DCA's learning management system, including a recent training edition titled How Leaders Navigate DEI Dialogue in the Workplace. The training is provided by Christopher Beal, who has 25 years of coaching, training, and leadership development experience. It offers tools for effective conversations, psychological safety, and how it impacts these conversations, and includes discussion around challenges leaders are facing. This training is available online and can be completed at your convenience. Should you have questions, please contact Board and Bureau Relations. Next, I'll talk about a legislative hearing related to interstate licensure compacts. Invited by the Senate Committee on Business, Professions, and Economic Development, DCA Director Kirchmeier testified last month at an informational hearing focused on interstate licensure compacts. The director discussed the impact of licensing compacts on consumer protection, licensees, and boards and bureaus, as well as the legislature. The director answered questions from the committee and provided examples demonstrating that compacts are not a one-size-fits-all solution. Rather, there are many factors for the legislature to continue, including the priorities of consumer protection and licensing standards that should not be compromised or lowered. 17 of the 36 boards and bureaus under DCA offer some form of reciprocity already, with several bills recently introduced proposing licensure compacts for DCA boards. The department will continue to work with the legislature on this issue. Next, I'll share information regarding complaint prioritization and referral guidelines for Healing Arts Boards effective March 1, 2024. In collaboration with the DCA Executive Leadership Team and the Executive Officer, Bureau Chief Cabinet, DCA's Division of Investigation updated the complaint prioritization and referral guidelines for Healing Arts Boards. The guidelines were shared with board leadership, and as of March 1, these guidelines should be used when determining which complaints to refer to the Division of Investigation and what can remain with each respective program. Of note, referral guidelines for the professions and vocation boards and bureaus are in progress and will be completed soon. Looking ahead, I'd like to remind members of the board to file your annual Form 700 by March 15th. Board and committee members are required to file a Statement of Economic Interest, Form 700, within 30 days of their appointment annually and within 30 days of leaving office. This year's annual filing period covers the prior calendar year, January 1 through December 31st, 2023. The official deadline for filing is Tuesday, April 2nd, 2024. However, to ensure compliance, DCA requests that Form 700 filers complete the e-filing by Friday, March 15th. You should have received an email from NetFile with instructions on how to file your Form 700. If you have any questions or would like more information related to filing, please contact Melissa Gear. Next, board member orientation training will be on March 27th. DCA board members are required to complete BMOT within 1 year of appointment and reappointment. The training provides an important overview of the roles and responsibilities of a board member and access to the variety of resources and support DCA has to offer. Board members can register through DCA's learning management system. The training will also be offered virtually on June 18th and October 22nd. This concludes the DCA update. Thank you again for the opportunity to join the meeting today. And at this time, I'll turn it back to President Hurley, and I welcome any questions from the board.
Thank you, Ms. Bucciarelli. Do you have any questions or comments? Excellent. Thank you so much. All right. Do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. All right. Moving on to item number 9, we have the budget update. Thank you.
Morning.
Good morning.
Thanks for allowing me to present today. My name is Andrew Trudy, and along with Suzanne Balkas, we represent the DCA Budget Office. I'm here to present the board's 23-24 FM6 projection memo, expenditure, and fund condition. We're going to start with the budget memo. This will give you a general overview of the board's budget, as well as percentage of the budget used towards expenditure. In 23-24, the board has a budget of $3,165,000. The board is projected to use 41.67% of its expenditure on personal services, which includes salaries and benefits. 25.39% for OE&E, which includes contracts, purchases, and travel. Finally, 37.26% for enforcement, which is for Office Administrative Hearings, OAH, and Attorney General, AG. The board is estimated to have a minus 4.32% in reversion. On the second page, we have the fund condition. We have 22-23 actual beginning balance of about 4.5 million with prior year's adjustment of 51,000. That gives us an adjusted beginning balance of about 4.6 million. We have an overall revenue of 2.8 million and total expenditure of about 3.1 million. That gives us a fund balance of 4.2 million, which is about 15.0 months in reserves. Next is current year 23-24, second column, which has FM6 projections included into it. 23-24 beginning balance of about 4.2 million. We have an estimated revenue of about 2.9 million, estimated total expenditure of about 3.4 million. That gives us a fund balance of 3.8 million, which is about 13.2 months in reserve. Budget year is based on governor's budget, and budget year +1 is based on realized. We have no immediate concern for this fund. The next document we have is FM6 23-24 projected expenditure. We have $1.3 million in personnel services and about $2 million in OE&E expenses, for a total of about $3.3 million, which created a deficit of about $137,000, or about 4.32% negative. We are monitoring the fund and have no immediate concern, and I'm available if you have any questions.
Just to add on that, because I know you're going to see the negative 137. So we are working with the budget office is working with Rosanna as well as the Department of Finance to get an AG augmentation for you for this year.
Excellent.
So that is going to be covering that deficit.
Excellent. Excellent. Thank you so much. Do we have any questions or comments?
Yeah, a quick question. So assuming we get that AG adjustment, then that's gonna pretty much reverse this trend we're seeing of months in reserve downwards, right? Okay.
And we're always trying to a little bit over project in some areas just for something unexpected. So of course, once we get more reports and more expenditure and as the months go on, so we'll be able to have more actuals and we'll be able to project better. But this is what we're projecting so far.
Any other questions or comments from the floor? Excellent. Do we have any public comments?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment on WebEx, would you like me to close that Q&A panel?
Yes, please. Thank you so much,
Thank you.
analyst team. Next, I'll move to item number 10 on the agenda. We have a report from the Medical Board of California with Dr. Hopkins.
Good morning, everyone. Am I clear?
Yes, you are. Thank you.
Okay, great. Good morning again, and thanks for this opportunity to report some of the important activities of the Medical Board of California. The Medical Board of California last met last week, February 29th and March 1st, 2024, in person in Los Angeles. The agenda is available at mbc.ca.gov. Live stream video recordings of the meeting will be available soon. Highlights of the quarterly board meeting include, number one, there was a presentation by Dr. Alice Kuo, MD, PhD from UCLA. The title was Rethinking Autism, Identity, Not Disease. Found it a very, very informative presentation, personally, updating us about the landscape of autism. I recommend everyone to actually view this video, particularly those who take care of children and adolescents. But autism, individuals go into the adult age as well, and there is a health disparity with those folks dying sooner than their peers. The second presentation and discussion on the final report of the Enforcement Monitor of the Medical Board. This was very instructive for the Medical Board of California about how the issues related to enforcement at the Medical Board of California. We'll be doing a deep dive in to see which one of the recommendations can be implemented. Very informative. So two highlights of the quarterly Medical Board were the presentation on autism and the final report of the Enforcement Monitor for the Medical Board of California. As a president of the Medical Board, there were some highlights. I'm going to give you highlights of my Medical Board presentation. One, as is this the PA Board, has some update on board composition. We had 2 resignations that occurred at the individual's request, and we had 2 new board appointees, governor board appointees, but we still had a deficiency in terms of board member composition, particularly on the non-physician side, public side. I gave notice of my attendance at the Federation of State Medical Board one-day symposium in January 24 entitled Artificial Intelligence in Healthcare. Very, very instructive, very, very informative. Our board will have a subject matter expert presenting on this subject in the future. I will let this board know when that occurs. It's going to be very, very important. This is a true expert in this area, artificial intelligence in healthcare. Next, task force appointment. The board will be reviewing the mental and physical health questions on the licensing application, and I will be appointing a task force of 2 board members to assist. As part of this review, the board will be holding an interested party meeting in the future. So there are issues regarding the mental health questions on the application and reappointment to the medical board. And there's a concern about these questions may limit individuals who have mental health issues commenting honestly about them because of fear of discipline, et cetera, et cetera, et cetera. So we're looking at that again as other state boards are. Next, maternal mortality issues. Are you aware that there are excess mortality in certain populations, African American, Hispanics, in California and in the nation? But so maternal mortality issues were presented and discussed at length at our medical board meeting in August 2023 in Bakersfield. And I indicate I'll be participating in an observership at the next California Pregnancy Associated Review Committee meeting April 19, 2024. And at this committee, they review deaths in women 90 days after, I believe 90 days after delivery. So I'll be participating in an observership at that meeting. Finally, there were restatements of some of the important new priorities of the medical board. Now that we have an approved fee increase, we fought hard for that. And with the support of a number of entities, including the public, certain legislators, et cetera, we did get the fee increase that we needed, at least preliminarily we need. First, an online complainant tracking system, which will allow complainants to track the status of their complaint. This is one of the things that is being developed. Second, a complainant liaison unit. We need to get staff for that. And third, the complaint or representative interview prior to closure of quality of care cases. This is one of the requests, not unreasonable by the public, that for these quality of care cases before closure, that the complainant or the representative can have an interview. That was a mouthful. Thanks again for the opportunity to participate in the PA board and PA board activities. This ends my report, and I can try to answer questions if they're in, if I need to elaborate on anything further. Thank you very much.
Thank you, Dr. Hawkins. I have a quick question. I know that you increased, I think, your fees by $80, if I'm not mistaken. And are there any problems, or do you hear any, difficulties or any issues, from your medical?
Well, we increased it by substantially more than $80. So a couple years ago, the legislator allowed us to increase our fees by $80, which was an insignificant amount and substantially less than what we requested. And now the fees are up substantially more than that. There were complaints. Organized medicine, a particular entity, fought that hard, but we could not do our job. The medical board was functioning on loans. And so the medical board had not had a fee increase in 15 years. So it's substantially more than $80, but it's what we need to be able to do the work that the citizens of California require in servicing the missions of public protection.
Excellent. Any other questions or comments?
Sorry, go ahead. Thank you. Hi, Dr. Hawkins. This is Dr. Alexander. In your report, you mentioned complaints of physicians. Are you seeing an increase in complaints, or what's the focus and purpose of these committees or task force?
So we have a substantial number of complaints at the medical board. Some of them are in our purview, and we address them. Others are related to other entities, and we forward them to the appropriate entity. But part of what the public has said is that we don't know where we are in our complaint. There's an accusation that's been made, and perhaps there's been a decision that the investigation will go forward. And they like to be able to know where they are because they can't get any information about that. So this complaint tracking process will allow the person who made the complaint to see where they are. You're in the investigation stage, or perhaps it's gone to the panels to be reviewed. So they'll be able to track where it is. So that was the purpose of that. Transparency. Charles, does that make sense?
It does. It does. I commend the medical board for putting a system together like that. But thank you.
You're very welcome. What we are trying to do is to let the public know that we're responsive. We hear them. There are challenges at times, as you might imagine, with things like patient loss or disability or deficiency. Sometimes it's hard to convince an individual that we're working hard. One of the responses to my question about why over 300 days, and we have those as well, in terms of closing cases, and our numbers are going down as well. Well, there's something called due process that, and individuals have the right to defend and present evidence that is essential in the evaluation of the complaint. And so, in an attempt to be transparent, appropriately so, giving an individual a status update within the limitations of the law is what's being provided with this complaint tracking unit.
Board member, board member
Sorry?
Armenta smiled
Yes,
when you said due process.
We try.
Yeah.
Yeah.
Dr. Hawkins, Dr. Alexander, kind of was asking about the same topic. So it sounds like this, and by the way, I think it took your leadership over there to get that done. So thank you for getting that done. I think it's an important step for transparency, but it sounds like this is going to be strictly disclosing process. Nobody's going to be able to access even the complainant substantive material, correct?
Correct. And there are only certain individual would be able to access that. And as you suggest in your statement, certain information is not going to be provided about the specifics of the case at that time. There's an approval process about what this looks like that has to go through DCA, legal, et cetera. And so I would correct that it's been a team effort. We're familiar with teamwork here. The prior president, Christina Lawson, and at that point I was a vice president, along with the medical board staff, worked very, very hard to get some of the important recommendations of the public and the staff to really service the mission of the medical board. So it's a team effort. It goes back over a couple of years for sure. One of the issues we have, and we're not isolated in this, is that we need legislators to help us do things that we need to do. And I'm going to stop there, except to say that when we were given an $80 increase in fee, it was insignificant and accomplished nothing for us to our mission. When we got the fee increase that we now have, is substantial and can allow us to meet the mission of the medical board. But we need to continue to improve the working relationship between the legislators so that we can do the job that we're required to do. So hopefully that's not too much mumbo jumbo. We are serious about the mission of the Medical Board of California, but the board and staff cannot do it on their own.
Understood. Thank you, Doctor. So, Madam President, the reason this popped in my radar, I think once we see what their model looks like, that's something we should probably keep an eye on.
Yes.
Because it'll be odd to have medical board do it and not us.
Exactly.
Yeah. So anyway.
Well, I'm happy that Dr. Hawkins is at the helm, so he can actually help us to do the same thing if it's working in the right fashion.
Yeah, I agree.
Mhm. Any other comments from the floor or questions? All right. Public comment.
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment on WebEx, would you like me to close that Q&A panel?
Yes, please. All
Thank
right.
you.
I think, thank you. Thank you, Dr. Hawkins. I think we're going to move for a brief break. And so we'll take a few minutes. We can begin again at 9:55. Is that efficient? Okay. All right. See you back. Okay, it is 9:55 and we will reconvene the meeting. We will wait to make sure that everyone is in attendance. Dr. Hawkins, do we have you available?
Yes, I'm back. Thank you very much.
Excellent, excellent. All right, with that being said, we will move on to agenda item number 11. Discussion and possible action on proposed 2024 board meeting dates. So we do have a host of dates that we would like to discuss. With the move from our February meeting to the March meeting today, we want to consider other dates and making sure that we're still within our 100-day limit. So we'd like to see if we can change the meeting from April 29th, 2024 to May 20th, Monday, May 20th, 2024. Does that meet everyone's calendar? So we are looking at new dates for board meetings, and the first proposed date would be moved from April 29th to May 20th. Is that good for everyone's schedule?
Be held.
It would be held here in Sacramento. All the meetings will be held in Sacramento, except for one, which we're going to talk about in Los Angeles. But the next meeting would be in Sacramento. Is that correct?
There is a conflict, but I can still do it if that works best for everyone.
Okay. Okay.
Been working out. Thank you.
Excellent. Does that mean everyone else's schedule? May 20th, I think May 20th is okay. Great.
I'm fine.
Excellent. Yes, Dr. Hawkins? Does that meet
Yes, I'm
your?
fine. Yes, I'm fine, May
Excellent.
20th. Thank you.
Okay. And next, we would like to change the meeting date from Monday, May 5th to Friday, August 9th.
It's the Monday, May 5th.
I'm sorry. Yes. Change the meeting from Monday, August 5th to Friday, August 9th. Does that meet everyone's schedule?
Is that in Los Angeles?
So the August meeting would be in Los
Southern
Angeles,
California.
Southern California.
Hawkins is fine. It actually works better for me.
Okay, great. Yeah. Christy Shields.
Meeting on that day, but since I'm probably going to be phoning in anyway, I can probably work my schedule around it.
Okay.
So if August 9th is better than August 2nd, which is the other date you had
Yes.
available. I can make it work.
Okay. That would be best for me. I have a college student who will be going back to college. So I will not be able to be here. So if you can, that would be great.
August 9th.
August 9th.
Thank you.
Does that meet everyone else's schedule? Okay. So currently we have Monday, May 20th, and then also Friday, August 9th. And we will continue with the November meeting being Friday, November 8th, which was already on the schedule. Okay.
Good morning, Madam President, members, Michael Canotes, Board Legal Counsel. Your executive officer asked me to just briefly give you an outline of the meeting options that are now available under the Bagley-Keene Open Meetings Act. There's been a lot of fluctuation over the pandemic. We had a waiver, and then we had statutory authority to meet completely the virtual means, and that has now changed. So as of January 1st, first of all, we have some finality, I think, in terms of at least the next few years in these meeting provisions. So at the moment, there are three options for us. The first is the traditional in-person board meeting where everyone is there in person and there is no ability to attend via WebEx, telephone, and the public also don't have the benefit of appearing for public comment on WebEx. You could have WebEx attached to, but all board members present at the traditional board meeting. The second is the new option, which, unlike the waiver and statutory authority that we had during the pandemic, requires a majority or a quorum of the board to be physically present in the room. And then the additional members above a quorum may appear via WebEx or a different type of medium virtually. They also need to keep their cameras on, and there's a provision that requires if anyone is present with them that they disclose that. The exception there is children, to disclose children. And then the third option, which we've always had, is the traditional teleconference option, where it is a virtual meeting. The difference there is that all of the locations where members are present need to be publicly noticed and accessible meeting places. So it's almost a fiction that the meeting is occurring in all these spaces simultaneously. The big drawback with that is, well, there's the public participation spot, so we don't encourage members to use their personal home or a place where they wouldn't want to have the public, because any member of the public can attend there. And the other drawback is if any of those locations go silent, we have to adjourn or cancel the meeting, because we have to have, even if there's no public in attendance, we have to have it. So are there any questions? So that's, I'm sort of recommending to my boards that to notice the meetings using the hybrid method, presuming we're going to be using WebEx, because then if nothing else, it gives you the opportunity to allow a member that may need to attend virtually at the last minute to do that. So you have a lot of different options in terms of how you want to conduct the meetings.
Okay, great. Any comments or questions?
Hawkins here. So we didn't have a quorum last time. What is a quorum number, please?
5.
Quorum number is 5.
Thank you.
So it is very important for us to make sure that we can make the meetings, and if not, let us know in advance so that we can make the appropriate adjustments. Is there a motion to accept those meeting dates?
I'll make that motion.
Excellent. Is there a second?
Second.
Excellent. Is there any comments from the WebEx or public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Yes, please. All right, Ms. Hurd, and you call the vote.
Aye.
Juan Armenta.
Aye.
Sonia Irvin.
Aye.
Diego Vincenta.
Aye.
Vasco Diakit.
Aye.
Deborah Smith.
Aye.
Excellent. Motion passes. Moving on to agenda item number 12, we have Christy Shields. And so we're going to update discussion and possible action on the proposal to amend CCR, California Code of Regulations, sections 1399.502, 13.99540, 13.99541, and 13.99545. And that's Senate Bill 697, implementation, proposed modified text and consolidation of public comments. And again, that's Shields and Ms. Dillon.
Good morning, everyone. It's wonderful to see a lot of friendly faces again and to meet new people. I'm really excited to work with the board again and with Board Council Canucks. My name is Christy Shields. I'm current regulations counsel for the board. I was board counsel for the board at the time SB 697 was proposed, as Ms. Khan mentioned earlier. In April 2019, I provided the board with a detailed analysis regarding the legal effects of the legislation if it were enacted. Most notably, we discussed at the board's April 2019 meeting the fact that the legislation, if enacted, could supersede any regulations that require personal presence prescribed to the qualifications for specified medical services or how medical services must be provided pursuant to a practice agreement, which is.
Are you close to the microphone? You're breaking up intermittently. I'm sorry. You're breaking up intermittently.
Okay, is that better?
Keep
Much
talking,
better.
please.
Is that better?
Much better.
Keep talking.
Okay. All right, so I was just giving the background for the board of my opinion and what you're seeing in the meeting materials.
That's better.
So a little bit of context with respect to this current item that you're going to be discussing. So at the time in April 2019, we discussed the fact that the legislation, if enacted, could supersede any regulations that require quote unquote personal presence, prescribe the qualifications for a PA to perform specified medical services, or how medical services must be provided pursuant to a practice agreement, which was formerly known at the time as a delegation of services agreement. Since Business and Professions Code sections 3501, 3502, and 3502.3 as proposed to be amended by that bill would set those requirements in law. In addition, SB 697 struck the board's previous rulemaking authority at B&P Code section 3502 to establish quote unquote alternative mechanisms for the adequate supervision of physician assistants by regulation. This was section 3 of the bill, Business and Professions Code section 3502, subdivision C3. I recently reviewed the law in these areas, and my opinion regarding the legal effect on the board's regulatory authority remains the same. Under the Administrative Procedure Act, which is the law that governs adoption of regulations by state agencies, at Government Code section 113 or 2.2, no regulations are valid unless authorized and not inconsistent with the board's enabling laws, which in this case is the Practice Act. As a result, it is my opinion that any regulatory proposal that retains requirement for the supervising physician be physically present, have a personal presence, be available in person, or be immediately available to attend a patient would likely not be successful when presented to the Office of Administrative Law, which is the agency responsible for reviewing and approving proposed regulations. For these reasons and the reasons set forth in the memo provided to the board in the meeting materials, staff and I are recommending that the board accept essentially all of CAPA's comments on the last modified text proposal and revise the proposed regulatory language as set forth in the second modified text, which is provided to you in attachment 1. The board agrees with the proposed responses as set forth in the meeting materials and text. As proposed in attachment 1, we are requesting that the board pass the motion set forth in option A on page 8 of the memo. Mr. President, I will ask if any of the board members have any questions for me at this time.
I do have a question, if I may, Madam President.
Yes.
In your view, we really are not, I don't see any of these changes affecting the substance of what we were trying to accomplish, right? These are all.
Well, I think that what has changed significantly is the attempt to retain some elements of personal presence, which is the prior text. If you look in attachment 2 of the meeting materials, we've struck any reference to requirements for being in person, being required to be immediately available to return to the patient. So the overall recommendation I made back in 2019 was that if the board had concerns about retaining its regulatory authority to just set minimum standards for supervision, that they should oppose the legislation. And the board did for a time, but worked out agreements with sponsor and author, and ended up supporting the legislation to the governor in September of 2019. And so, however, the issue with respect to removing your regulatory authority to set the standards for supervision, because the practice agreement by statute sets the standards for supervision, that would supersede your regulatory authority. That still remains that issue. So if the board has concerns about that, it would be something you'd want to maybe seek a legislative change for, but you couldn't do it through a rulemaking. And that's what I was attempting to explain in the memo. Maybe got lost in there, but I know there's a lot to read. But essentially, CAFA was raising a lot of the arguments that we had discussed back in 2019, which is that the board no longer has authority to prescribe how surgical procedures are supervised by a supervising physician with respect to a physician assistant. And so the board attempted, it looked like to me, to retain some of that in that modified text notice that you last sent out. So my recommendation would be to strike that. So that is a substantive change from our last meeting, which is why I kind of went into that long background statement for your information. So if you look at the modified text, for instance, you'll see the double strike through. Whenever you see double strike through and double underline, which is highlighted on mine, you can see it, but it's also an italicized double strike through and double underline for those with visual impairment. When, for instance, you look, the biggest issue is 1399.541. You look at page 3 at the bottom. So here the board had previously said, perform surgical procedures without the personal presence of a supervising physician. And then continued to say that under local anesthesia or sedation, including procedural sedation or general anesthesia, the physician assistant shall ensure the supervising physician reviews documentation to indicate the physician assistant is trained and qualified to perform the surgical procedures under sedation. Then it goes on to say the physician assistant shall ensure the supervising physician surgeon's perform an assessment for the patient's physical status and fitness is appropriate to undergo the procedure. Then the biggest contention was in 2 on page 4 at the top. The contentious issue was the board had attempted to put in a definition that says the physician assistant may so act without the personal presence of the supervising physician if the supervising physician is immediately available to the physician assistant. So then if you go to 3 for the definition of immediately available, it's essentially the same as what your current regulation says, except that it removes the word return to and substitutes it with attempt. And immediately available was proposed to be defined in your last modified text notice as a supervising physician is physically accessible and able to attend to the patient without any delay to address any situation requiring supervising physician services. And I mean,
Okay, hold on. Where are you reading from? Right there? What page of the memo?
4, see the double strike through that I have there, immediately available. So that's the big change right there.
You mean page 5?
Page 4
4
of
or
the
5.
second modified text. Attachments. I'm looking at attachment 1.
Attachment 1.
Oh.
So this is the suggestion I'm making. Of course, you can always feel free to reject legal advice in this matter, but this is the recommendation is that you strike immediately definition of immediately available and any of the aforementioned sentences I mentioned about controlling the supervising physician's discretion as to how to supervise their physician assistant, which is on starting at the bottom of page 3 in I-1. So you'll see the stuff that's been struck out is the stuff that you had in the prior, is the text you had in the prior notice. And I'm saying I would recommend you take it out because the law sets the standards for how supervision occurs by a supervising physician now.
Well, I don't see that. I don't see that it says it. All it says is shall not require the immediate presence, right?
No, what it said is they shall not require the personal presence.
Personal presence, I'm sorry. So the statute says shall not require the personal presence, right? So if we use, what's the Latin phrase, ulterius unis, that if they knew, we presume the legislature knows what they mean when they're talking about personal presence is a precise definition.
This is our text, not statute.
It still applies.
Right, but the
That's statutory
statute,
interpretation.
right, so statute at 3501 was amended.
To
Okay,
not require personal presence.
no, what it says is nothing in this see. It's 3501, the definition of supervision. F1 says shall not be construed to require the physical presence of the physician and surgeon. So that's the standard.
Okay,
You can
physical
never
presence.
Okay,
Physical presence then has a certain definition.
and the board has defined it as personal presence in regulation. Physical presence meaning personally available to attend.
I disagree with that. Physical presence means you're in the room.
No, you can be in the building, it can be general, a bit general available to return to patient.
Yeah, that's the problem we have. We don't want somebody on a large campus that is not available if we have an emergency.
I understand that the public policy issue you're mentioning, but my opinion, and it is only my opinion, is that ship sailed when SB 697 was enacted. It says in 3502 that the requirements for the practice agreement. First of all, supervision says that
3501.
3501F. Okay. Not adherence to the adequate supervision is agreed to in the practice agreement. So adequate supervision is decided in the practice agreement, not by board regulation.
Okay, well, is there any interpretation by case law? I know the answer to this for what 3501F means. There is not.
There isn't.
Okay.
But there's a lot of ledge history, and I quoted that in the memo. And the legislative history was that to remove the board's authority to set those standards by regulation. That is the ledge history supporting the bill. And so I think you're going to have a difficult time retaining the immediately available definition in text. I think you're going to have a hard time saying that personal presence will be required unless they meet your criteria. So, because again, I believe the bill SB 697 removed the board's authority to decide how supervision may be minimum standards for supervision in the practice agreement. That is decided by practice agreement. And 3501 sets that standard, and 3502 supports that interpretation. If you look at 3502, it says, notwithstanding any other law, which means nothing else matters but what we say here. A PA may perform medical services authorized by this chapter if the following requirements are met. The PA renders the services under the supervision of a licensed physician surgeon. The PA renders the services pursuant to a practice agreement that meets the requirements of 3502.3. And if you go to 3502.3, this agreement shall include provisions that address the following: the types of services they're authorized to perform, policies and procedures to ensure adequate supervision of physician and assistant. And there's, a list of things that has to be in the agreement. The methods for CE, furnishing of drugs, any additional provisions agreed to by the physician assistant and physician surgeon. Has to be signed by both parties. And then nothing in each section shall be required to require the approval of a practice agreement by the board. So the board doesn't have authority to approve practice agreements or to set the content of those anymore.
I take that to mean that we don't review the individual practice agreements. I don't take that to mean that we are giving essentially under the interpretation I'm hearing, is almost complete autonomy provided it's provided in the practice agreement. In other words, if a practice agreement says you can do general anesthesia, full surgery without my immediate availability, under that interpretation, they could do that.
Yes, they can.
Okay, I don't see that in the legislative history. I do not see where total autonomy was given when they're continuing to require us to supervise PAs. They're continuing to require us for our mission statement to protect the public. And it really comes down in the final analysis to that physical presence. How do you define what that means? So under statutory definition rules, it's expressio unius est excelsior alterius, means the expression of one thing necessarily excludes the others. The legislature could have said, you may not require immediate availability or any type of presence whatsoever. They didn't say that. They said physical presence. So the question is what did they mean when they said physical presence? To me, it means in the room. That's the most logical sense in this context of physical presence.
I guess I'm not understanding how the definition you've proposed in the modified text for immediately available is any different than requiring someone to be physically present. I don't see.
Because you could call somebody.
Unless they're physically present.
Well,
Yes, but when they get there, they're physically present. So that's a physical presence requirement. When they get there,
I see your argument.
So that's the thing we can't require. We're strictly prohibited from requiring it by statute.
Can I make a comment?
Yeah.
So I would agree with you 100%. The focus of the practice agreement is that supervision is determined at the practice level between the physician and the PA, not prescribed by the board as to what supervision looks like. That is determined specifically at that level. It is up to the individual credentialing and privileging bodies to decide what the PA can do with the physician and with the PA, right? So let's say, to your point, that a PA can, give anesthesia and perform cases. That has to be approved by the credentialing and privileging body of a health system or a hospital. They don't usually allow that. There's always a physician or there's rules and administrative policies around that, right? So even though you have a practice agreement, there's still a delineation of privilege agreement and administrative policies and bylaws and regulations that PAs and physicians are still required to follow. So there's a lot of checks and balances along the way that protect the patient at the systems level. So I'm in agreement with Kappa's comments. I'm also in agreement with the interpretation that we cannot require the physical presence of a physician. And I think when you're looking at supervision in general, there's different ways of how that's defined. So general supervision is to be electronically available. Direct supervision is to be somewhere in the suite in case something happens. And personal supervision is to be immediately available in the room as something is being done. That's how supervision is traditionally defined for PAs and for nurse practitioners. So when we think about it, I just want to make sure that the board has that context.
No, the thing that I find most persuasive is the extension of, okay, so now you've called them to the room. Now it sounds like physical presence. However, it gives me great pause to go there because I just don't see the clarity of that in the legislative history. I don't see the clarity of that. If they meant, go for it, you'll have nearly complete autonomy. Why wouldn't they have said that? That's a huge thing that the bodies lobbying for SB 697 wanted, right? That was.
So if you look at page, I'm going to direct you to page.
Is this attachment 3? Page 8?
Yes.
Okay.
Like this second paragraph. Assembly Committee Analysis and Explanation SB 697, July 9th, 2019. Thus, except for those enumerated restrictions on PA practice set forth in Code Section 3502, which cannot be waived or altered by practice agreements, All other matters relating to the relationship between the physician and surgeon and the PA, including who does assessments when, are by decree of state law exclusively a matter between the parties to a practice agreement. If the requirements of the statute are met, PA may lawfully do the things authorized by the practice agreement, and no regulation that impedes conditions or sequences that entitlement is a lawful one. Whether a PA may perform a surgical procedure after the PA's assessment is an exception. So,
Well, that's their reading. That's their interpretation.
right, but,
You know,
but if you look at the Assembly being code analysis, they say repeatedly, and
And that's my point. If they say repeatedly in the analysis, which isn't the final bill, in the analysis, they're saying, we want, let's just call it for the sake of argument, autonomy. Covered by the practice agreement. You understand my shorthand here. If that's what is in the analysis, and it didn't make it to the final bill, I think a court is going to have a problem with that.
well, I guess what I'm having a hard time understanding is that it says notwithstanding any other law, a PA may perform medical services authorized by this chapter if the following requirements are met. And if it says that they meet the requirements of 3502.3 and you go to 3502.3 and it says that they decide what the services they can perform are, I don't see how the board has any authority to say otherwise. That's the concern I have, is notwithstanding any other law, you understand is that.
No, I
no matter what it
understand.
says anywhere else.
I understand.
This controls, and it says they may perform the services if they meet the requirements of 3502.3, the practice agreement. Now, this doesn't prevent the board from disciplining if they fall below the standard of care. It doesn't prevent the board from taking any actions, but it does prevent the board from setting minimum standards before something occurs. And I understand that that's the concern you have, that we don't set those minimum standards at the beginning before something negative happens potentially.
The
But
license.
that was what I explained back in 2019 could be the consequence of that bill being.
Well, here's where I disagree with you. B, notwithstanding any other law, in addition to any other practice that meets the general criteria set forth in this chapter, or regulations adopted by the board.
Where are you reading from?
3502B, 3502.3B. They specifically gave us license to enact regulations. B, notwithstanding any other law.
Point three, sorry.
Yeah, notwithstanding any other law, in addition to any other practices that meet the general criteria set forth in this chapter, or regulations adopted by the board. So it specifically gives us license. In fact, they're telling us adopt regulations to implement this.
Yeah, if I may, I would be careful with coming up with minimum standards for supervision. I think that is best determined at the practice level. The board is not an expert on all the areas where PA would practice, and the expertise lies in the practice, right? Based on a number of factors that hospital systems, doctors' offices, clinics look at to determine the competency required to perform the task and activities, right? So that should be determined. We don't want to take that away from the physician and the PA. They're the experts, they're in the field, and they know what level of expertise and competency is required, to do whatever they do in that clinical space. So I don't think the board has the ability or shouldn't come up with prescriptive minimum requirements for supervision. That needs to be determined at the practice level. That is the intent of Senate Bill 697 and why it was supported by many constituent organizations, so that the PA and the physician are determining the level of supervision. And I think that is important, and that's what we need to continue to look at as we think about these regulations for Senate Bill 697.
So in the section you're talking about, subdivision B of 3502.3, that has to do with exemplars of the types of services that may be authorized, which we're going to, if you look at regulation section, proposed section, there's a list. We didn't recommend it here. Medical services performable. So if we look at 1399.541, starting at the beginning of A, that's the regulatory authority they're talking about. not the ability to set standards for supervision. It's the types of services that they perform. That's what that reg authority is for. Not to set standards for how physicians and physician assistants determine the content of their practice agreement and the level of supervision. They specifically removed this board's authority to set alternative mechanisms for supervision standards from the board's authority in their practice act by that legislation. So we continue to, the board continues to retain its authority here to list the types of services that can be in a practice agreement as exemplars of what services can be performed. And the purpose of that is to allow people that are unfamiliar with how to do practice agreement kind of a blueprint for the things they could put in a practice agreement. And so that's why we're amending this section, and we're adding the last proposed subdivision, perform any other services authorized by the practice agreement for which the physician assistant is qualified. Because there are qualification requirements at 3502 that they still have to meet by law, but the board doesn't set those standards.
Well, why is it not a reasonable interpretation to look at B and say, notwithstanding what rules you make, board, the practice agreement can still do 1 through 3. In other words, board, you can make regulations, but you can't affect 1 through 3. That's the way I read that. This is a carve out exception.
May is discretionary. May authorize if you.
Right.
So it's discretionary. Yeah. And so,
Yeah. So the practice agreement can say, even if if we made a regulation that said no durable medical equipment, let's say, this statute would say, now, sorry, board, we don't care about your regulation. The practice agreement can do it. If we said certified disability under the unemployment code, you can't do that. This section says, sorry, board, the practice agreement can do that. This carves out exceptions. This carves out limitations on our regulatory authority. So again, let me go back to what you said. I would agree with you completely if that sentence did not appear, or regulations adopted by the board or the medical board. If that doesn't exist, I would agree. But here's the problem with giving the expertise to the practice agreement. I don't think you can point to a single board that doesn't exercise authority with, if you want to call it, incomplete knowledge of what's happening in the field. That's just the nature of the beast, right? Medical board, I think Dr. Hawkins would say that we enact medical board regulations and having incomplete data on what that looks like in the field. Bureau of Automotive Repair, their board does things without necessarily understanding about the latest technology of hybrid vehicles. Okay, so I think it's an imperfect system. We're humans. It's government. It's going to be imperfect, right? But I really have a problem with overlooking. The legislature did not have to include that, but they did.
Okay, so let me just clarify what I think they're trying to do here. It says,
Okay.
notwithstanding any other law, in addition to any other practices that meet the general criteria set forth in regulations adopted by the board. So it's this plus anything else that the board would like to put in there, like I said, their exemplar language, which is what we're doing here. And again, it doesn't allow us to prohibit things from being put in the practice agreement. It allows us to say, we agree that this is something that physician assistants can perform as part of their, and it's the type of service that is performable and that it is in practice agreements. And I think, again, the purpose is to allow people unfamiliar with how physician assistant and supervision by supervising physician work to know what duties are dealt can be prescribed by a practice agreement. So this is existing language that was left in from the prior Practice Act. This is not something that was added by SB 697. It was left in there.
It was from the delegation of service agreement.
Yes, it was in there prior to SB 697. And so we have to read it in that context, in my opinion. Otherwise, what was the point of them putting together language that says supervision can be done if it complies with the practice agreement requirements in law, and the law says that you can do anything as long as they adhere to these standards. And if they're competent, they're qualified by training and experience, and it's agreed to by the physician and to ensure the adequate supervision. They decide what that supervision is going to look like and whether it's adequate. Again, it doesn't remove the board's authority to discipline if there isn't that those qualifications are in fact not met.
No, I get that
So-
part. I mean, that's not even a question. It's just troubling. I don't see how the legislature left that in there. Because you could make the same argument, just because it's left over doesn't mean it's meaningless. It could be an affirmative decision. Hey, we're leaving that part in. So that the board does have regulatory authority.
Right, and I don't think that our interpretation here is inconsistent with what the way it reads.
I do. If that the interpretation you're offering, I mean, we had a significant amount of negotiation with all of these people to get to this board, to get to these regulations.
Well, I understand that happened and I wasn't here for that.
No, you were not. And this was that everybody agreed to, and now they're clawing back and saying, oh, that part that we said that's good, let's take that out now. That troubles me simply from a negotiation point of view. Okay, but still, I can't accept how that interpretation of B 3502.3B does not state, no, you still have regulatory authority.
Right, to do additional practices that meet criteria for performance.
That's not what it says. It says notwithstanding any other law or board regulation, no matter what else happens, your practice agreement can still do this. It can still order durable medical equipment. It can still sign off on a plan for home health care. It can still certify disability for unemployment. So no matter what regulations we do.
So so if I may, I think that the practice agreement would have to follow existing rules and laws on the books already. So I don't think it can usurp things like Title 16 and other things that may pertain to certain situations. So typically when you develop a practice agreement, you're developing a practice agreement with an understanding. As an example, if you have someone who comes in for a workers' comp, you can't put them off for more than 3 days as an APP, right? As a PA or an MP, right? So you can't put in the practice agreement that you can give them a week off as an example. So you still have to follow current rules, at the state level. So I think the practice agreement, again, Christie's point, really is focusing on supervision of that PA in the clinical environment and what the PA can and can't do based on skill set, competency, and what they're privileged to do. So for me, I don't think that the board has any authority to establish minimum supervision requirements based on the way that I read the law. Now, I'm not a lawyer, but the intent of Senate Bill 697 was to put it in the hands of, again, and I'm sorry for reverberating this, but put it in the hands of the physician and PA at the practice level. That's what Senate Bill 697 is designed for. And to Christie's point, there is a blueprint of things that should be properly included in the practice agreement. By the way, the nurse practitioners in AB 890 have language of a blueprint of things that could be included and some of the things related to that piece of legislation. So I think at the end of the day, we have to move this regulatory package forward. And we're running out of time. And I know we can go back and forth on what should it include this or should it not. But at the end of the day, the text, the codified text that we have before us, in my viewpoint, and I think hopefully other board members share similar sentiments, is that this is to the letter and intent of what the legislation was designed to do, which was, again, put it in the hands of the physician and PA who know their practice best. And I think this. So if we, the board, start saying, no, this is what a minimum supervision requirements, we take away from the practice to determine that on their own. And I think that does an injustice for patients and an injustice for the PA and physician practices.
I think my concern is not so much the commenters as the Office of Administrative Law and what arguments I would make for retaining some of these changes that were proposed in the prior modified text, because I don't know what our argument I would make.
Exactly.
What I'm seeing in the statute.
Exactly.
Oh, I do. It's pretty clear to me. If we're before a court of appeal, it's absolutely clear. So when you talk about intent of a statute, okay, there's rules that we go through for statutory interpretation. First thing is plain meaning rule. If it says don't run a red light, That's what it means. It doesn't say, oh, but there's an exception here, you can turn right on a right, okay? You use a plain meaning rule. If the plain meaning rule does not inform, then you turn to legislative intent, okay? To me, the plain meaning rule here is pretty clear that regulations adopted by the board, that's a general criteria that the practice agreement has to meet. So my view is that that is a reasonable requirement for general anesthesia. The parties that negotiated this all agreed to that. And believe me, I spent a lot of hours in those rooms working on this, okay, with Jed, and I think Sony was part of it too. And it was like herding cats to get to consensus, but they ultimately agreed that that filled our mandate of protection of the public. And I don't think it is particularly onerous. And with this sentence, I think it's a reasonable thing to require. I'm a little more troubled by Christie's argument that, well, doesn't physical presence mean that when you call them in, you're requiring physical presence? Yeah, that's a little more troubling. But overall, I would be opposed to changing the immediate availability component.
And I'll just say I would prefer, thank you so much. And by the way, thank you for your work on that. I know it's not been easy to kind of go through the Senate Bill 697, and we appreciate the legal hat and expertise you bring to the table. I do think that the codified changes, again, just to reiterate, are in line with Senate Bill 697, and I'll be making a motion in support of these new changes. Thank you, Christy, for your work on this and for your legal expertise as well.
So are you moving option A as set forth in the materials?
Is that the motion?
Option A is, let me just read it.
Yeah, please.
Where are you reading from?
Page 8 of the meeting material versus action requested.
Okay, let me get there. Hang on. In the future, can we have these dates stamped with a separate numbering?
It's at the top.
No, I know, but there's several pagings from the attachments, everything else.
Oh, yeah.
So I think we should probably in the future, we
Yeah,
just have a date stamp
Perfect.
for the whole compendium. Okay.
Okay, so option A is adopt the proposed responses to comments in the second modified text and direct staff to send the second modified text in attachment 1 out for a 15-day public comment period. If no adverse public comments are received on the second modified text, instruct the executive officer to take all steps necessary to complete the rulemaking process. Authorize the executive officer to make any technical or non-substantive changes to the rulemaking package and adopt the amendments to 16 CCR sections 1399.502, 1399.540, 1399.541, and 1399.545 as noticed in the second modified text.
So that is the motion I make.
Option A, right?
Yes, option A.
Okay.
Option A.
Okay. Is there a second?
Before we go, I did want to add one.
Point of order. I apologize. There's a motion on the floor, so it has to be, we have to deal with
Yes.
whether there's a second or not, and then we can discuss the motion or more discussion if there's not a second.
Is there a second? A second? All right. Any comment?
My apologies. No worries, no worries. So I did have a question about 1399.541 at the beginning where it just lists the specific examples. I feel like that could lead to potential interpretation that's an exhaustive list, and it could exclude other, valid settings that aren't mentioned. So I would maybe suggest replacing it with saying something like any organized healthcare system setting.
Where are you reading from? I'm sorry.
At the very beginning of 1399.541, where it says in any.
Well, it says
An example.
any setting, including, for example, so that means that there's no limitation on other settings.
Yeah, I would just, wonder if it, could be interpreted as an exhaustive list and someone might,
I would say no, and I think I'm a little concerned about changing it because this regulation provides for examples and it's not, and it specifically says in any setting, including, for example, meaning it's not an exhaustive list. So if we go and start adding categories, then it might look like it's an
Yeah.
closed list.
I wouldn't say adding categories. I would just say replace it with something generalized that would allow for flexibility and adaptability as the healthcare system and settings evolve over time.
I mean, are these settings that are generally recognizable by them?
They are, and you bring up a great point, Diego, and I appreciate that. Any setting that could be an academic medical center setting, that could be a clinic setting, that could be a site of service 11, site of service 22, any setting where a PA could practice. So we want to leave it as broad as we possibly can.
Exactly.
Because we know PAs practice everywhere.
Yeah, and that's why I would just suggest saying just any organized healthcare system setting.
Well, if you just put setting, because some of them are not organized systems, like a doctor's office is not an organized health system. So you would, by saying any setting, you're just saying any setting where the PA would practice. That's again at a academic medical center setting, at a vertically integrated healthcare setting, at a doctor's office, at a FQHC. All of those settings would be included in this.
Yeah, if I may, Diego.
Yeah.
I think Christy will agree with me on this. So the legislative interpretation rule here on this does not exclude anything.
Yeah.
When the legislature says, including, for example, it's meant just an example. It is not a limiting list at all.
Yeah.
So when you say in any setting, that captures everything.
Everything. Yeah.
Thank you.
Excellent.
Thank you, Diego.
Those are excellent questions. Any additional comments on the floor? Do we have any public comments?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. And it looks like we do have a request on WebEx from Brett Bergman. And Brett, you will be given 5 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Can you hear me okay?
Yep.
Yes.
Perfect. Brett Bergman, past president of the California Academy of PAs, speaking today on behalf of the California Academy of PAs. First, I want to thank the board for all its work and due diligence with the proposed language in option A. CAPA expresses our support of option A. I want to comment on PA board members Armenta's concern of the PA regarding performing surgery independently on a patient under anesthesia. And I'd like to re-highlight the legislative language that's found in 3502, the restrictions on what a practice agreement can authorize a PA to perform, found in subdivision 3 and 4, and that is that the PA has to be competent to perform the services and that the PA's education, training, and experience has prepared the PA to render those services. So if under 3, the PA is not competent, or if under 4, the PA does not have the education, training, or experience, they cannot render the service. The practice agreement cannot authorize the PA to perform a service that they are not competent to perform. I agree with PA board member Kidd's assessment. Hospitals and surgical facilities are accredited by numerous governing bodies nationally, as well as numerous California government agencies. And the process of privileging is how a facility indicates what services a PA can perform in the surgical setting. That's also aligned with 3502 in that privileges are granted based on competencies. So if not competent, they cannot be granted those privileges. A PA would not have privileges to autonomously perform a heart transplant surgery independently, as they are not competent nor trained to do so. And in fact, nor would an orthopedic surgeon who has a plenary license under California law is not restricted by the nature of their medical license, but rather based on the standard of care and the hospital in granting those privileges. In fact, even 3502 subdivision F states that the PA shall be supervised by a physician and surgeon with privileges. Again, highlighting the aspect of the importance of privileges in a hospital or surgical setting of what a PA would be authorized to perform. And lastly, as PAB Council mentioned, the remedy and within the board's authority is discipline for any PA whose conduct falls outside of the standard of care and outside of the language that's found in 3502. Thank you very much.
Thank you. Are there any other public comments?
This is the moderator. Appears there are no further comments on WebEx. Would you like me to close the Q&A panel?
Yes, please. Okay, Ms. Hurd, can we call a vote?
Well, can I
Yes, please.
appropriate from your comment now?
That's up to the president.
You can comment.
Yeah. So, you know, I worked with Brett on this at the beginning, and I certainly respect his opinion, but to me, that does not change the statutory interpretation that I believe is there. So that was my only comment.
Okay. Any other comment? All right, Ms. Hurd, can we call for a vote?
Aye.
Juan Armenta,
No.
Sonia Hurley,
Aye.
Diego Souza.
Aye.
Marco Diakis,
Aye.
Deborah Snow. Aye. That concludes the vote.
Great. All right,
Motion passes.
and the motion passes.
So just a question. So now what happens is it goes to the public comment, do all that, we'll get public comment. Okay.
Right, and we're hoping we don't get any further comments, but if we do, we may need to have another meeting because, as just mentioned by Ed, we're running out of time to complete this rulemaking, so we need to make sure that we try to get everything filed as soon as possible. Because July seems like it's far away, but it's
Really?
not.
So what happens if we don't? What?
If you get no further adverse comments, then we proceed to file the rulemaking with the Office of Administrative Law. And there are 3 attorneys there that will be looking at it to see if you're correct or I'm correct, or if the board's interpretation with the second modified text.
Or it's too close to call, or whatever they come up with.
Well, they make decisions. They're decisive in their opinions.
Okay.
So we'll know one way or the other whether it'll be approved. If it's not approved, it will come back to you. If your points are taken.
And that was my question. So
They will
let's
see
say,
your comments in the minutes. And
so that's my question. Let's say for whatever reason, we don't get it passed. What happens? Because you said it's a July deadline. What happens after that?
they have 30 working days to review the file. And if we have enough time it needs to be withdrawn and brought back to the board, then we'll try to schedule another board meeting to address OAL's required changes. And then we'll send it out for another notice and hopefully wrap it up at that point. Because once the OAL's told us what changes they need to be made to make it consistent with the law, then that's it, so to speak, unless we get an adverse comment from that. So it's going until the board decides it doesn't want to make any more changes, and the OAL doesn't want us to.
Okay, so we're not going to be all taken up for beatings if we don't make it by July.
No, we have to start over, which
Okay.
is what we're trying to avoid. We're trying to get this done. I know I've been working on it for years
Yep.
now.
Yeah.
So,
Again, if I could.
Yes, please.
So thank you so much. I really appreciate
Yes.
your work, and Mr. Armenta as well. Thank you for your work over the years. I do think we really do want to try to usher this through because we are running out of time. And just to Christie's point, we have the nurse practitioner bill that recently passed, and they have their regulatory package already done, and they passed after we passed Bill 697. So we are really behind, and we really need to. We're playing catch up here, so I think it's really important for us to try to meet the deadline of June or July? Of July 26th. So we just can't entertain endless comments over and over again. I think there needs to be an opportunity that if there are some of these reverberated, redundant comments, then maybe as a board we can just move forward to get the legislation up to OAL for review and see what their comments are. If their comments are similar to what we're hearing, or if they want to go ahead and move the legislation forward.
yeah, so the motion is written that if you get an adverse comment, it comes back to you because the discretion with respect to changing any rule resides with the body and not with staff. So we can't make those decisions of whether to accept or reject a comment, even if it's redundant. We have to bring it back. And as your counsel, I'd recommend you keep it that way.
Okay.
Right.
Because you don't want to ever delegate away your discretion. In fact, the Attorney General's office says you can't delegate your discretion to a subordinate because it's in statute that you're the rulemaking
Right.
body.
Right.
You exercise the discretion when it comes to.
And we wouldn't want to do that.
We
I
wouldn't want to
wouldn't,
do
I
that, for sure.
would think you would.
No,
We would not
no.
want to do that.
Yeah,
This is your opportunity to make law, and
Right.
you don't want to delegate that away.
absolutely.
Exactly.
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 All right,
Well, I
thank you, Chris.
appreciate all of the comments, that this was a great dialogue for us to go through, and thank you again. For making
So
it fun
Jasmine,
for
we'll
us.
do our best to get that to the finish line.
Excellent.
We're counting on you to get us to the
Thank you
finish
so
line,
much,
right?
Zoe. All right, excellent job. All
Thank
right,
you.
so let's move on to the next agenda item. That's agenda item number 13, regulations, update on pending regulatory package by Ms. Dillon.
So the first package, SB 697 license renewal and continuing medical education required. At the November 6th, 2023 meeting, the board voted to adopt the revised regulatory language. And staff is currently working on the initial documents with Regulations Council and the Budget Office to submit for initial review. The next package, SB 697 implementation, which was just discussed. Agency approved this package on July 13th, 2023. The notice was filed with Office of Administrative Law, publication on July 28th, 2023, to initiate the 45-day public comment period, which ended on September 12th, 2023. 3 comments were received, and at the November 6th, 2023 meeting, the board adopted the revised regulatory language in response to the comments received. The 15-day comment period ended on December 20th, 2023, and 3 comments were received again. The board needs to adopt the revised regulatory language in response to the comments received. The next package, SB 697, application, exam scores, addresses, and record keeping. At the November 6, 2023 meeting, the board approved the proposed regulatory language to reinitiate the rulemaking process. Staff is currently working on the initial documents to submit for initial review. The next package, AB 2461, retired status to include fingerprint requirements. Staff will begin working on the initial documents to submit for initial review this calendar year. And the last package, implement uniform standards related to substance abusing licenses and update disciplinary guidelines. Staff will also be working on this proposed language in the next few months for board approval. That concludes the update.
All right, any questions or comments from the board?
My only question is priority. You decided which one, next one you wanted to comment, the application package. Okay, thank you.
Any other questions or comments? Do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close that Q&A feature?
Yes, thank you. All right. Moving on to action item number.
Thank you.
Thank you.
Thank you.
Thank you. Thank you so much. I appreciate you.
Are you leaving?
I am. Stick around.
That's okay.
Okay.
I'll beat you up later.
Okay.
Good to see you again.
All right, thank you guys again. Item number 14, Education Workforce Development Advisory Committee, update on physician assistant education programs and applicants in California. And that's Drs. Alexander and Dr. Kidd.
Thank you. I'm going to defer to Dr. My colleague here, since he prepared the report for the last meeting that was canceled. And so I don't want to steal his thunder, but I also just want to make a brief comment. I probably should have made it earlier, but I really appreciate the attorneys having a discussion about this most important issue. And to be blessed to have 3 attorneys in the room on top of that. So,
as I mentioned earlier, when I first started, I was like, we have the legal team. We
couldn't go wrong.
I'm in good hands. We're in good hands. Right? So we agree with you.
So thank counsel all councils for it.
Yes,
But
we appreciate it.
My blood pressure's through the roof.
And just, my blood pressure is down because I have such a good legal team that I mentioned before. We have an awesome team, and I really appreciate the dialogue and the expertise and the educational opportunity. So,
Dr. Kidd.
yes.
Thank you, Dr. Alexander, and also appreciate your input into this report as well. So the total number of accredited PA programs stands at 306. Total number of California accredited PA programs is 21. The number of programs on probation is 3. The number of provisionally accredited programs is 5. The number of developing programs is 2. Cal State University San Bernardino is developing a PA program, along with Toro University, California, here in Los Angeles, is also developing a PA program. There are 2 other universities listed on the applicant, the RCPA applicant webpage, Alliant University and the University of St. Augustine, but neither I or Dr. Alexander could find a working website on these programs. So I'm not sure if they're still pursuing provisional accreditation or not. Current annual capacity of the 21 accredited programs is 1,056. Average number of students per cohort is 50, whereas the national average is 45 students per cohort. So we're about 5 above the national average. Geographic distribution, the vast majority of programs are in Los Angeles, San Diego, and the Inland Empire being Riverside and San Bernardino County. The Bay Area has 4, Sacramento and Central Valley have 2, and Central Coast has 2. I do want to bring your attention to Cal State University, Monterey Bay. Their program started in 2019 and then unfortunately will close in 2024 at the end of their 5th year, which for those who understand provisional accreditation, it's 5 years before you can move and become continued accreditation. So they're going to be closing in May of 2024 as the university has voluntarily withdrawn accreditation. The 2024 class will be allowed to graduate. Those are your seniors who are doing their clinical rotations and are eligible to sit for the Physician Assistant National Certification Exam. For the class of 2025, which just completed their didactics, the university is trying to identify accredited programs who would take their students so they can complete their clinical rotations. To date, only 5 of the 33 students admitted have been placed, according to the website. And many of you know, in order for a program to accept students from another program, they have to submit a change request for a class size increase. And there's no guarantee that you'll have the appropriate resources, clinical sites, in order to absorb those students from that, from that program. With the closing of California State University, Monterey Bay, and the limited number of folks that can go into Western University of Health Sciences, because as you know, they cannot matriculate students, we will have about 133 less graduates per year. And that will end my report.
Are there any questions from the floor? And I would
Yes.
just like to make a comment. Oh, yeah, go ahead.
I'm sorry, President Early, you were speaking.
I was going to say that's really difficult from the PA board standpoint, PA school standpoint, because each class is a designated class. So unless someone either leaves that cohort, you may not have an available spot. So it's really difficult to add on to that without making other provisions and going to ARC-PA to submit certain forms, which is a lot of paperwork. So it's going to be really difficult unless there's already open spots to increase those numbers, is what I'm guessing. So, any other comments? And Dr. Hawkins, you wanted to comment?
Yes, I apologize for the language I'm going to use and not knowing specifically which programs I'm asking about, but this is similar to the situation that happened at Monterey Bay. In terms of placements of PA students who have not completed the program, and there's been a problem with the program. In a prior board, there was a PA program that had issues with, I suspect, accreditation. I don't remember specifically, however, and there were a number of students that started that program, and they were looking at placing students who had started the program. And again, I'm apologizing, I don't remember the specifics. I don't have my notes handy. And so I'm similar to Monterey Bay, that other program, do we know what's happening to that students? Is anyone recalling the program that had difficulty and students needed to be placed in another program. This is not getting a rotation. This is being into another program. That's the nature of my question.
Yeah, so it's Western University of Health Sciences that had the challenges the last time that we looked at that, Dr. Hawkins. And so they reached out to JET's program and other programs to try to place their students. And as you eloquently articulated, Cal State University Monterey Bay is now in the same boat, trying to do the same thing in terms of placing their students for clinical rotations. So we have two programs that are currently on the bubble, and unfortunately, Cal State University Monterey Bay will be officially closing in 2024, May of this year.
So
I'm sorry,
I'm sorry.
Dr. Hawkins. Continue.
No, I added, I was going to ask a follow-up question, but I wasn't sure if he was finished with his comments. So
I am Dr. Hawkins.
So is there a particular issue with, let's say, those two programs and the prior programs that are having difficulty that we need to understand? That is, are there reasons why these programs are having difficulty? Not with finding spaces for the students to rotate, we understand that, but some other issue that the PA board needs to be aware of?
Yeah, so they're having difficulty complying with the accreditation standards. There are a voluminous number of standards that PA programs are required to comply, and they're broken up into individual sections such as, curriculum and ongoing self-assessment and a bunch of other standards that programs need to be able to comply with. And so that is publicly reported. So every program has on their webpage the challenges that they're facing in terms of meeting specific standards. That is outlined all on their websites, and it's a requirement of the ARCPA that is publicly available. So that is the rate limiting step for these programs, is that they're not able to meet the accreditation standards. And so because of that, they're either placed on probation, or in this case, they are voluntarily withdrawing their accreditation.
Okay, so Juan, if I could do a follow-up before you comment, I think you were going to say something. So as we talk about what I think I heard, it was 10 programs that are in some stage of setting up a program, I think in California, you said, correct me if I'm wrong. Are they aware of the issues that some programs are having? And it may be out of our purview, but I'm just asking it because I mentioned earlier about the fact that we need more of all healthcare providers that provide firsthand service, PAs, nurse practitioners, and physicians. So they're important people, they're important individuals. Are they aware of the problems that have to do with accreditation as they start up another program? And that's the end of my question.
Yes, they are. I mean, I think everyone is fully aware of the standards and what the compliance is for that. I think most programs do their very best to try to comply with the standards, but the standards, I think we're now in the 5th edition standards, if I'm not mistaken, with the ARCPA, so they've evolved over a period of time. And it's just the program's ability to meet and comply with those standards. And that's really what the accreditors are looking for. So if there are challenges with that, then that, the accreditors will address that with the program specifically. But programs across the country are very keenly aware of the ARCPA accreditation standards and their ability to have to meet those standards.
Thank you very much.
Thank you. Board Member Armenta, did you have a question?
It was answered.
Okay, great. Any other comments? All right. Any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, please. And thank you so much, Vice President Kidd. Excellent. So now we will move on to report of the legislative specialist, legislative update by Ms. Dillon.
Just to give you an idea of what positions
So the first bill is AB 2194, physician assistant supervision podiatrist. This bill was introduced on February 7th, 2024, and is located in New Assembly. The Physician Assistant Practice Act establishes the Physician Assistant Board for the licensure and regulation of physician assistants. Current law authorizes physician assistants to perform prescribed medical services pursuant to a practice agreement and under the supervision of a licensed physician and surgeon. Current law authorizes physicians and surgeons and doctors of podiatric medicine to establish a professional partnership that includes both physicians and surgeons and doctors of podiatric medicine if specified conditions are satisfied. Existing law authorizes a physician assistant performing medical services under the supervision of a physician and surgeon to assist a doctor of podiatric medicine who is a partner, shareholder, or employee in the same medical group as a supervising physician and surgeon. Current law requires a physician assistant who assists a doctor of podiatric medicine in this manner to do so only according to patient-specific orders from a supervising physician and surgeon, and limits the physician assistant to performing those duties included within the scope of practice of a doctor of podiatric medicine. Current law also requires a supervising physician and surgeon to be available to the physician assistant for consultation when assistance is rendered. This bill would delete these provisions establishing the conditions under which a physician assistant may assist a doctor of podiatric medicine, and instead would expand the existing supervising physician and surgeon provisions to authorize a supervising podiatrist, as defined, to supervise a physician assistant in a similar manner. This bill would limit a physician assistant assisting a doctor of podiatric medicine pursuant to these expanded provisions to performing those duties included within the scope of practice of a doctor of podiatric medicine. In regards to physical impact, staff may need to implement regulations in accordance with this bill, and the board would need to update forms and information included on the board's website for licensees to reflect the new supervision requirements. This is something that can be done by staff and is supported by the board's current pro rata cost to DTA.
So as one who has worked with podiatrists and has been involved in the training of podiatrists, I absolutely oppose this bill. There's a total of 11 podiatric programs across the U.S. They graduate about 560 podiatric students per year, or graduates per year, I should say. There's already a mechanism, as you mentioned and eloquently pointed out, about assisting a podiatrist in a practice, right, where typically it's an orthopedic practice and a podiatrist will work for an orthopedic practice. And so the PA can assist a podiatry under the supervision of a licensed physician, whether that be an allopathic or an osteopathic physician. So I don't think we need to include podiatric surgeons as a part of that kind of group of folks that could supervise PAs when a mechanism already exists. I don't see a need to do that from a board standpoint, that this would be something we would support, given that there's, again, already a mechanism and a venue in place to assist podiatric providers. In addition to that, there are other folks that do supplement podiatric providers in terms of the care they provide for foot and ankle. And for those, everyone here, at least the PAs know, but for people who don't know, podiatric folks typically oversee or provide care for foot and ankle injuries, right? So whether it's elective or urgent or emergent cases, they provide care for that population of patients. But there are other services that are provided by orthopedic surgeons, foot and ankle surgeons that also provide that level of care. There's family medicine physicians that also provide diabetic wound care. There's also wound care clinics that also provide some podiatric care as well. So again, looking at this legislation, and as a person who's worked with podiatric providers, which are fantastic and they do a great job, I don't think that this bill would be something that the board should support, given that we currently have a mechanism for assisting those providers. I know that was a mouthful, and my apologies.
I would have to agree.
You know, if I may.
Yes.
So in my legal practice, what I found, because I do a lot of workers' comp, is it's interesting that podiatrists often get to a better solution because I think of the focused training than a regular ortho does. However, I'm troubled by this bill because it removes completely 3502B.
Yep.
That is inconsistent with fact with the position I took on the prior regulation. And I may be revisiting that, but here's the problem. I should have pointed this out earlier, but here's the problem I have. There's nothing that prevents physical presence when we have somebody on probation, right? Or as a manner of discipline. So if that's true, then that is inconsistent with Christie's prior argument that you can never require physical presence. Those two things don't square up, I don't think, but motion carried, so we'll see. But yeah, for the reasons that it takes apart 3502B, I'm opposed to this.
And just to add to that, when you're on probation, we have a list and a host of things. I mean, usually those will require presence of your whole list of things, but presence of that physician and surgeon. So
right, and that you see my conceptual difficulty of squaring those two. Okay, well, if it's, as Christy was arguing, it's completely out of your list of things you can do. Oh, okay, but it's over here. The legislature told us we can when somebody's on probation or discipline. So maybe that's our safety valve, but it's just interesting that those two things don't seem to square up. But
The ship has sailed one.
it is. I see it. It's down there.
The ship has sailed. The other comment I would make on this too is section 935. 169A, it says the Podiatric Medicine Board of California may restrict a podiatrist to supervising specific types of physician assistants, including but not limited to restricting a podiatrist from supervising physician assistants outside of the field of the specialty of podiatry.
Correct.
Right? So PAs are not trained to be podiatrists. There is no training where, and my PA colleagues here can correct me, there is no requisite rotations with podiatrists in order to meet the accreditation standards. They're not. So we don't train with podiatrists. There's no accreditation standards that podiatrists be included as part of the requisite rotations required to graduate from a PA program. Therefore, again, I have opposition towards this bill.
that is correct. And then looking at PA, we have certain guidelines, and podiatric medicine is not included in that. And as you mentioned, we don't have any clinical rotation that would support that. And given the numbers that Vice President Kidd mentioned, that is going to be difficult to do in order to be compliant in that specialty. So I would have to agree.
So should I make a motion? Can I make a motion to oppose? To oppose. I'd like to make a motion to oppose this bill.
Is there a second?
I'll second.
Excellent. And so we can move on to AB.
We should go ahead and
Take a vote. Okay. Ms. Sarah, would you like to? Yes. Public comments. Yes.
If there's no more,
Yes.
if there's no more,
There's no more. Yeah.
I think you have.
Yeah,
Yes.
I mean, I'm just curious to learn where this bill came from. Is it from a podiatrist? Is Patterson?
It's Patterson. I don't think he's a podiatrist, but I'm not sure.
I think it's a really safe bet that it came from a group of podiatrists.
Oh,
Yeah.
sure.
And, you know, at times legislative reports will have that information, but this was just filed, so there's no analyses that have been completed as of yet.
Because I agree, the training is quite different.
Yeah.
You know, for a podiatrist versus a physician, whatever.
Yeah.
So I agree with you, Dr. Kidd, in terms of your perspective on it. So, but that's my comment.
Excellent. All right. And so public comment.
All right, this is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close the Q&A feature?
Yes, please. All right. And Ms. Herr, can we call for a vote?
Aye.
Aye.
Diego Ensenza. Pascal Diakite.
Aye.
Arista. Aye. And that concludes the votes.
Excellent. We can move on to B.
Item number B, AB 2442, Healing Arts Expedited Licensure Process, Gender Affirming Healthcare and Gender Affirming Mental Health Care. This bill was introduced on February 13th, 2024, and is located in the Assembly. Current law requires our board to expedite the licensure process for an applicant who demonstrates that they intend to provide abortions within the scope of practice of their license, and specify the manner in which the applicant is required to demonstrate their intent. This bill would also require those boards to expedite the licensure process for an applicant who demonstrates that they intend to provide gender-affirming healthcare and gender-affirming mental health care as defined within the scope of practice of their license, and would specify the manner in which the applicant would be required to demonstrate their intent. In regards to fiscal impact, this bill would require staff to update the board licensing process to ensure applicants who meet the gender-affirming healthcare and gender-affirming mental health care criteria can get their license application expedited. This would require the license application form to be updated for applicants to demonstrate their intent, and staff projects there would not be an increase in licensing workload related to the new provisions of this bill.
Yeah, why do we need this?
Yeah, exactly. There's no bottlenecks, there's no
Right.
throughput issues in terms of processing applications. Why is this warranted?
I think there was a similar bill that was attempted to get passed last year that didn't go all the way through, so this might be similar to that.
Okay.
But it was just introduced, and I'm still in talks with the staffers of the bill to get
Okay.
more information.
And we have less than a 30-day.
It mainly applies to other.
Board.
Yeah.
Yeah.
Okay. Okay. So I don't think this would apply to our board.
So, Madam President, may I suggest that we just take a watch position until
Yes.
it develops further?
Yeah.
Does that make sense?
I would think so. Does anybody want to take a watch? Any comments? Questions? I would agree. So we can move to take a watch. All right, so would I have to take a?
So the board can take several positions on a bill. You certainly can make a motion to watch the bill, but I think your staff will already be doing that. A watch really is not an official
Okay.
position of the board.
Okay, perfect. Okay, so you'll continue on. Excellent.
So item number C is SB 1041, Physician Assistant Licensure Armenian Doctor Pilot Program. So this bill would establish the Armenian Doctor Pilot Program to be operative from January 1st, 2025 to January 1st, 2027. Under the pilot program, up to 15 doctors who graduated from the Yerevan State Medical University and have attained their medical degree and medical license in Armenia, but have not practiced in California within the 10 years preceding the operative date of the pilot program, would be eligible to participate in the program. This bill would require the participants in the program to be enrolled in a medical refresher course developed by Yerevan State Medical University and an accredited academic institution in California with an approved physician assistant program, which would be subject to approval by the board. The bill would require classes to be provided by Yerevan State Medical University and the approved California Educational Institution via a distance learning program. The bill would require the refresher course to include clinical training undertaken in a federally qualified health center that serves the Armenian community in Southern California. The bill would require the board to issue a license to practice as a physician assistant in a federally qualified health center for 2 years to a participant who satisfies the requirements set forth in the bill. The bill beginning April 1st, 2025 would require federally qualified health centers to begin assessing the work of the participants of the pilot program. The bill would also require the assessments to be submitted to the board and would require the board to review the findings and discuss the future of the pilot program. The bill would repeal the pilot program on January 1st, 2027. And in regards to fiscal impact, this bill would require staff to update the board's licensing process to ensure applicants who meet the pilot program requirements are licensed. And this bill would require the license application form to be updated for applicants to apply for the pilot program. And staff projects there will not be an increase in licensing workload related to the provisions of this bill.
I have comments, but
Yeah.
I'll let you start. I will let you start.
So I was just at a fundraiser for a congressman who's an ER doctor. And he had invited several doctors to discuss streamlining the educational process to mirror some of our colleagues from India or other countries where they're right into the program from high school. Now, that global approach federally makes sense to me because we're acquiring more doctors. a narrow program for this one university. I don't like that. I don't like that it is now imposing additional licensing requirements on us and development of a program. And if this is going to be anywhere, why are we doing it? If they want their medical degree and your MD, sorry, Dr. Hawkins, but I think we should a 9 right over to the medical board. So my view is I would vigorously oppose this bill.
Well, I am in agreement with you, and let me go on to add. So I would have to agree. These, we used to call them foreign medical graduates, but international medical graduates. They have MD degrees. In order to practice as a medical doctor in the United States, they have to pass the USMLE, and I believe that there are 3 parts. If these physicians cannot pass that examination, they cannot be physicians in the United States. PA physician assistants are not secondary. This is something that people choose to do. And so if they can't meet the requirements of the medical doctors, they can't probably meet our requirements. And so we are not a step down profession. And so if these physicians have been out of practice for 10 years, that is well above the numbers, the years that we don't allow our PA students to come in. Usually it's 7 years or less. And so you can see that they're out of compliance, not in addition to practicing outside of the United States. So their standards could be subservient to, well, submissive to ours. So, and then also we mentioned ARC-PA, that's our accrediting body. The ARC-PA says that we can't make any additional pathways to become a physician assistant. And so there is tons of standards that we have to make sure that we are proficient in and following by. And so this would be outside of that. And then also, as board member Arminta mentioned, it imposes a different scope of practice for the board. And so again, if we go back to our mission is to protect and serve through licensing, education, and objective enforcement of our laws and our regulations, this is well outside of that. So I would vigorously, as I can include with PA Arminta, that we do not, we just oppose this law.
And I also just want to add on, just so I have some comments on the record as well. They wouldn't even be eligible for the physician assistant national certification exam, right? And so based on all the comments that have been made, you can't complete all your rotations at a federally qualified healthcare center because you need surgery and emergency medicine and other requisite requirements that you sometimes can't get at an FQHC, right? And then they would be competing with other PA students for clinical rotations. And clinical rotations is a rate limiting step for PA programs. So bringing in additional foreign graduates into the mix only displaces PA students in their rotation. So I, for all the reasons that have been already articulated, plus the reasons that I'm sharing, I adamantly oppose this bill.
Right. And then we have Dr. Hawkins that would like to comment.
Yeah, I'd like to go on the record of agreeing with all the comments that have been mentioned previously about this. Thank you.
Excellent. Do we have any other comment? Yes.
Michael Cadotes, legal counsel. Just briefly, as your legal counsel, the legal division doesn't take positions in terms of the legality or constitutionality of bills. However, I do think I should raise that this bill certainly creates an issue as to whether it's unconstitutional based on national origin discrimination. So just add that to your.
As equal protection.
Yeah, that's
yeah.
Excellent.
What I'm talking about. Yeah.
Excellent.
You know, that was going to be my comment as well. But I also have an underlying question as to the motivation behind this. I mean, is there a lack of Armenian PAs in this particular community? Is this one of the reasons why they're doing this? I know that some years ago, I think it was 2007, the Dental Board allowed Mexican dentists to come into California and practice dentistry in the Central Valley because of the shortage of qualified dentists. And so I'm just wondering if there's some other hidden motivation behind this bill because of the fact that there's not.
Right. I'm unaware of that. And I think our, if I would just take a leap, I would think that all of our programs are doing a great job in trying to make sure that they have a complement of all races and nationalities in their programs. the program that I work at specifically, there is a nice component of Armenian PA students. So I don't think this is a PA issue. I think it's a medical doctor issue that they cannot pass their USMLE examination coming into the United States. So they want to practice medicine somehow. And they think that we.
So you're saying there's an underlying motivation.
There is an underlying, I would assume that
Of
there is
some
an
sort,
underlying
yeah.
motivation. It's not a PA problem issue, motivation, but it is but then again.
I can get 9 iron to the.
Again, there might be a line item to go, like PA and to mention to the medical board, because that I think is their main issue. If they could pass the USMLE examination, I don't think that we would even be looked at.
Thank you.
Yeah, thank you. Any other comments? It was a great dialogue.
Dr. Hawkins, may I comment?
Yes. Yes, please.
So can't address Dr. Alexander's inquiry, except it does remind me about the Mexico pilot program, which has been relatively successful in California. And there's been a request, AB 2864 Garcia, extension of licenses for the individuals that are participating in that program that's been quite successful in providing physicians who meet the medical standards required and are providing services to underserved members in parts of California, Spanish-speaking Mexico pilot program. And so we support, if amended, to make sure there's some additional factors, which I won't go into, that allow that program to be supported. But this is a totally different program that has proven efficacy, no extra discipline, and a whole host of reasons why we should continue that. One of the important questions was, is the Mexican government oppose this program because physicians are being trained in Mexico, licensed in Mexico, or providing services in the U.S. And so I'm not going to say any more about it than that, but this would be the comment that I would mention, and I'll refer you further interest if you have some on AB 2860, licensed physician and dentist from Mexico program, and extension of the Mexico pilot program, Assembly Bill 2864. Thank you.
Great, thank you.
Dr. Hawkins, Dr. Alexander here. If I do recall, though, did the boards also visit these institutions in Mexico to determine the standard in order to allow this this process to take place? I think I read something
Initially,
about
yes.
that.
Yes.
Unlike this particular bill, there's no visit from PAs or physicians to determine whether or not this university is up to standard.
Yep.
So.
And again, I would go back to the Mexico project. That was MDs to MDs, not MDs to PAs. So
yeah,
significant difference. Yeah. Any other questions or comments? Those are great. All right. Would we like a motion to oppose?
I'll move to oppose this particular piece of legislation.
Is there a second?
I'll second.
Awesome. Excellent. And so do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close that Q&A feature?
Yes, please. So we would like to call a vote.
Aye.
Aye.
Diego Insulza.
Aye.
Vasco Diante.
Aye.
Deborah Snow. Aye. That concludes the votes.
Excellent. And we can move on to your last item, SB 1067.
SB 1067, Healing Arts Expedited Licensure Process, Medically Underserved Area Population. And this bill would require each Healing Arts Board to develop a process to expedite the licensure process by giving priority review status to the application of an applicant for a license who demonstrates that they intend to practice in a medically underserved area or serve a medically underserved population. And in regards to fiscal impact, this bill would require staff to approve the board's licensing process to ensure applicants who meet the medically underserved area or serving a medically underserved population criteria can get their license application expedited. This would require the license application form to be updated for applicants to demonstrate their intent, and staff projects there will not be an increase in licensing workload related to the provisions of this bill.
How's that different from what we just said earlier with, I think the previous bill where we talked about that, right? We have no throughput issues. We're processing, meeting our 30-day mandate. So I think we would be taking a watch position, I think similar to what we did for the other bill. I mean, unless the board disagrees with
No,
that.
I would agree.
That makes perfect sense to me.
Mhm. Any comments or questions? All right, any public comments? Okay, thank you, Ms. Dillon.
Sorry, this is the moderator. At the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close that Q&A feature?
Yes, please. All right, so moving on to agenda item number 16, agenda items for next meeting. Do we have any additional items that we'd like to discuss in next meeting? I think there was only, I guess, a board activity report just to put in specific data that was mentioned by board member Menta for Ms. Caldwell and the licensing issue. I don't recall any other information. Please correct me if I'm wrong.
Can I just get clarification on our attorney? You mentioned something about the meetings being remote, hybrid.
That's something that'll be decided by the board president and staff as we move forward.
Okay.
Any other comments? All right. Public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. Oh, and it looks like we no longer have any members of the public on the call. Would you like me to close the Q&A feature?
Yes, please. Definitely. Yes, please. All right. And moving on to our last action item, we have no closed session today, so there's no information to discuss. So we will adjourn and conclude the PA board meeting, and thank you all for attending.
That's a first.
Congratulations on your
Thank
first
you.
good meeting, well run, Madam.
Absolutely.
Thank you.
It's 11:28. We're adjourned.
There's
Yeah.
11:39 and we are adjourned. Thank you.
Awesome.